Welcome to the Bodacious Women in Cannabis podcast, the show where the bold and brilliant women cannabis business leaders share their journey and their expertise. Here's your host, Susan Burns.
Hi, this is Susan Burns, your podcast host and your on-call business lawyer focused on the business of cannabis and supporting bodacious women in cannabis on their journeys to success. Today, we are talking with Mary Shapiro. Mary is a cannabis lawyer with Evoke Law in San Francisco, California. Mary is also a founding board member of the International Cannabis Bar Association. Welcome to you, Mary.
Thank you, Susan. It's a pleasure to be here.
So excited to have you and to talk to you. So I want to get a little bit about your background of how you became a quote unquote cannabis lawyer or started working in the cannabis industry, and what a little bit about the boring things you did before cannabis.
Well, they certainly weren't boring. I had a 20-year career in book publishing. I worked in retail, I worked in manufacturing, and I worked in distribution, which when I decided to go into law, I thought was a really good foundation in terms of understanding businesses and clients. There's a long story about my Velcro epiphany, which I'm going to spare you right now unless you want it.
About your what? Sorry.
My Velcro epiphany. I was at a trade show for the book company I was working with at the time, and basically we ran out of Velcro. And I was turning 40 the next day, and I was thinking, I'm turning 40, and my biggest challenge in life is finding Velcro. What's gone wrong? And then I came back home to New Jersey at the time, and I was driving the car, and I was going doctor, lawyer, Indian chief, and Indian chief wasn't going to happen. Doctor wasn't going to happen. Lawyer, that would be intellectually challenged, which would be the opposite of trying to find Velcro. So I basically signed up for the LSAT course and took the LSATs and went on to law school.
Okay, so you took the LSAT, went to law school.
I had a lot of friends in publishing, and one of them introduced me to a gentleman by the name of Ed Rosenthal and his wife, Jane Klein. And they owned a publishing company, which is how she knew them, that was publishing books about cannabis. And she took me to a party there and at their home, and they often had events where they were doing fundraising. I can remember clearly going to one in their backyard where the speaker was a woman who had her child removed from her custody because she was using cannabis. And there was no other indicia. There was no other issue. And so I started really getting interested in it. And in 2009, when I formed my own law firm, Ed Rosenthal was kind enough to introduce me to Steve D'Angelo from Harborside, Eric Pearson from Spark, and Robert Jacobs from Peace and Medicine. I started helping them with their brand protection. Steve was a visionary. He totally understood how important branding was going to be in the cannabis industry because of the fact that it's a commodity. So you have to do something. And anyway, going back to that intellectually challenging aspect of kind of the opposite of Velcro, the challenge in cannabis was and is that cannabis is considered unlawful at the federal level, being in a Schedule I designation. And so I had to try and figure out how to get them some brand protection. And I basically looked at what they were doing. And at that point in time, as still today, many cannabis businesses offer education because they understand that the consumer doesn't really fully understand what cannabis is, what it can do for wellness, for medicine, for recreation. They don't really truly understand it. I observed that each of the cannabis companies I was then working with had basically had information and education. So I pioneered the filing for information services and providing education about cannabis, and was able to get federal registrations because I always considered education and information free speech, and I refer to that as they're the free speechy marks. That's how I got in, and that's how I navigated the challenges of getting federal trademarks for clients at that early stage and on to this day.
Very fascinating and bodacious of you, if I might add, Mary. So for background for the listeners who don't know, because marijuana is illegal at the federal level, you cannot successfully register for a trademark this is a legal theory that's being challenged, but because based on the USPTO's information, it's an illegal product, so therefore you can't avail yourself of the legal protection of trademarks. So what Mary was just talking about is she found an ingenious way to successfully register trademarks at the federal level. So kudos to you, Mary.
Thank you. I like to call it threading the needle. Like the whole
threading the
thing about
needle.
cannabis and being a lawyer, you can only advise clients to do what's lawful.
Yes. So do you have a favorite part of what you're doing today, Mary, since you overcame the Velcro moment and are now in something that's always intellectually challenging every day?
What do I find challenging now? Well, actually, it's the same thing I found challenging 10 years ago, now that you asked the question that way, because it's still not federally lawful. I basically thought that cannabis would become lawful in 5 years, 8 years, or whatever. And now it's been 12 years since I've been practicing cannabis trademark law, and it's still not lawful. So I'm basically still stymied by that challenge, which I realize that there are bigger fish to fry, whether it's banking or whether it's 280E. But having brand protection is huge in an industry that is emerging in this manner. And I suppose the particular challenge right now, it being exponentially larger because of what's happening in the industry, is that because it's unlawful federally to register a brand protection at the USPTO, you end up with all of these states that are siloed. So you end up with a testing company in California by brand ABC, and then you end up with a retailer in Oregon with that same brand, and then a hemp company that sells nationally and maybe even internationally, and then another company that's doing edibles under that same brand. And so it's a recipe for consumer confusion. And when I say consumers, I mean both medical cannabis patients as well as adult users. Because the thing about cannabis that I think most people will agree with is that it's very personal. Like the dosing is very challenging because it's personal. It's not based on size. It's not based on anything, any other metric that you can easily identify. So you have to do a lot of experimentation to make sure that you're getting the results that you're looking for, regardless of whether you're trying to address epilepsy or whether you're trying to enjoy the evening, the two extremes. Well, I think they're the two extremes. So you end up trying out different products, and then you want to get that same result, and you go back to the dispensary or your delivery service, and you're looking for the same product, and it may not actually be the same product because there are so many confusingly similar brands out there that are not able to do the kind of brand enforcement that regular businesses can do.
Yes, and I mean, to that point, that you can have a product that has the same quantity of THC or maybe a combo of CBD and THC, just to keep it simple, but different terpenes will make the experience feel entirely different. And, like tuning this to the endocannabinoid system of each individual person, which is so unique, is a tough thing, as you mentioned. I did want to just make sure that, because you had mentioned 280E, those in the business, the marijuana business, understand all too well what 280E is. But for those who aren't in the business yet, the 280E is a reference to the Internal Revenue Code section that says any expenditures in connection with the illegal sale of drugs, which marijuana is still a Schedule I controlled substance. So it's an illegal drug. You cannot deduct your ordinary business expenses. There are some exceptions, but that's generally the rule. So business deductions are not available by and large to marijuana businesses. So that's what you were referencing when you were talking about the complexities of this industry. Talk to us about any hidden benefits that you found along the way, Mary. Is there something you said, wow, I never would have thought this cool thing would be happening to me in this part of my journey?
I think that is an easy question for me to answer because I loved being in the book industry. I love books. I loved reading. I loved marketing books. I love bookstores. So I love everything about the industry. And then I went from being a bookseller, for lack of a better word, but a bookseller, to being a lawyer. And well, Susan is a lawyer, and I love Susan. And there are many lawyers that are not very much fun. But
That's so true.
going into the cannabis sector, I have that same feeling when I go to a conference and I see all my colleagues, and it's just a joy. It's just, the industry is just a joy.
I agree. The people make it interesting and different. And I didn't know this about you, Mary. I didn't know you were a bookseller before you became a lawyer. I thought you had always been a lawyer, and that's why I said, what boring thing did you do besides cannabis? So that's really interesting.
That's the most bodacious thing I did, Susan, was I became a lawyer at 45.
That's a very bodacious move, Mary. Do you think that gives you an added benefit as a lawyer, that you have had a previously successful career?
I definitely think it does, especially in the field of intellectual property. One of the reasons I went into intellectual property was because I had this publishing background, and I knew something about vaguely about copyright. Not what I learned in law school, but I knew something about copyright and publishing. And then the second contributing factor was that once I left publishing, I was in a marketing position, and for about 9 years before I went off to go to law school. And that gave me some exposure to trademarks, and I really liked them. And again, because of that whole Velcro epiphany, I basically wanted to do something that was intellectually challenging, and copyright and trademarks fit that bill. And the experience business experience I'd had, really was easy to leverage.
Do you have advice, Mary, for other women in the business of cannabis?
I do.
Have any-
But it's interesting because of my own background and the age in which I grew up. And I feel like it may be different for different generations. But I think the one common thread that is apparent to me is you just have to follow your passion. You have to do something you really want to do every day and be excited about it. And I think for me that, following my passion into trademarks and copyright was really a great idea. And then getting engaged in focusing on an industry, the cannabis industry, that was another way of like amping that up and specializing. And, just as we both have said, the people in this industry are wonderful. So I think that's true. I think probably the cautionary tale, though, is I was lucky enough to grow up with parents who believed I could do anything. And I think not all women grow up in that kind of environment. And the cannabis industry is very male dominated. And it's very, like, if I can say, it's got a big bro culture. That's changing, I'll acknowledge, because of kind of the big money that's coming in and the professionalism that's coming in. But I think that can be challenging. I mean, I think you just have to meet it head on. You just have to either like meet it head on or ignore it and in a successful way. Good
advice and good insight, Mary. I think it's true more in we talk about the cannabis industry, and cannabis is a genus, and I don't know if there's species or whatever. I'm not a biologist, but we have marijuana and hemp, which are separated only by a legal definition. And I think my experience working in the hemp industry is much different than when I've represented clients working in the marijuana industry. It's totally different industry experiences. So I find that fascinating. But one of the things, and it's not as dog eat dog, I would say, but one of the things that I also find fascinating, and wondering if that's true for you, is that the law changes so much all the time, but maybe in trademarks and wouldn't be the same.
It is, and I think that's really an important, also very quite intellectually challenging to deal with, the laws and the way that they change. And I think to your point, it may not be that the law is actually changing, but as lawyers, we know that the law is the law, but it's the interpretation of the law that actually, based on the facts that are present, that makes the situation turn out one way or another. And so we do see situations, and I think I can talk about this one and another one. One of them is where one of my clients, and I don't do litigation, so I wasn't representing them, but they had a whole bench trial in front of a judge. By definition, that's what bench trial is. But they had this whole trial, and before that judge could issue his ruling, he passed away. And the ruling that ended up being presented really didn't acknowledge that medical cannabis and adult use cannabis are related. I mean, the judge who ruled thought of them as different channels of distribution. And that's not really true, because you could use medical cannabis and adult use cannabis, and a lot of people do, or you may only use one of them, but they're still related. So that was one weird thing that I thought was, because it was the interpretation. Now it's only dicta, and dicta, for the rest of you non-lawyers, is something in a case that isn't actually the holding and that is precedential, but it's hanging out there, and it can be used against you, or you can use it for you. The second situation was another situation, litigation situation. Again, I wasn't the litigator, but there's a concept in trademark law where by using a mark in commerce, you accrue certain limited rights. They're called common law unregistered rights. And in this particular case, the judge held that you can't take advantage of common law rights to challenge an existing federal registration. So there are just different
For marijuana?
Yeah, there are different for cannabis versus non-cannabis. It was an edible, basically. But I think that the point that I'm trying to make is that basically judges are now interpreting various nuances of whether it's trademark law, or whether it's bankruptcy law, or whether it's some employment law. And so it's really important how that court or tribunal or administrative body rules.
Mm-hmm. Yeah. It's a great industry if you're a nerd too.
Yes.
Because as you're talking, I'm thinking about all the creative, you mentioned dicta, and as I think of court writes an opinion, it's like an aside, like it's not critical to the decision, but it's an aside, and creative lawyers can do a lot with that. So that's just, I don't know. I like the nerdiness of the profession too. Mary, where can people connect with you?
So I am at mary@evoke.law. My website is evoke.law, no .com, no anything. That was one of the things I did early on. I was rebranding my firm from boring Mary L. Shapiro to Evoke Law. And I decided to take advantage of all the new top-level domain names that were now available, including .law, .legal.
Awesome. So evoke, EVOKE.law.
Mm-hmm.
That's where you're going to find Mary Shapiro, the one, the only. And I reciprocate that love, Mary. Thank you so much.
Thank you
for joining us today. And it's been an absolute pleasure to talk with you.